Margaret, Wille, and Paul Achitoff, and we're here at the Olelo Studios in Honolulu, and here to discuss the GMO-related County Council Ordinance, Bill 113 on the island of Hawaii, and doing so in the context of what else is going on GMO-related around the state and also nationally and the international efforts. And in that context, I just want to introduce Paul Achitoff, and if you'd like to say a few words, Paul, as to who you are in this conversation.
Thanks, Margaret. Yeah, I'm an attorney with Earthjustice, which is a national nonprofit public interest law firm that handles exclusively environmental matters. And I've been an attorney for about 30 years, and I've been the managing attorney of the Honolulu office of Earthjustice for about the last 20 years. And I've been working on GMO-related issues for probably the last 10, 12 years or so.
Okay. And I am the first-term county council member to the County Council on Hawaii Island, and that is the legislative branch, county legislative branch. So you have the mayor and the executive branch and the legislative branch. I'm one of 9 council members, and my background is cultural anthropology, and I have a master's in education, and a lawyer, practicing lawyer. So this is my first term, and how this came about and why it came about, I think there's been certainly a lot of concerns raised both here in this state and around the world in terms of the dangers and risks associated with GMOs. And for me, taking a look at just the state of Hawaii, the 3 other counties are all GMO ag dominated, whereas our island of Hawaii is not. And so this got me thinking, maybe with all of the cries and concerns, that maybe we ought to take a cautious approach and just say, hey, let's halt and not allow further spread of GMO cultivation or cultivation of GMO crops and plants here on our island until we take a closer look. So that's what Bill 113 is all about. It's actually very modest. It just says halt where we are, and it essentially grandfathers in all those who are currently engaged in the open air cultivation of GMO crops. And again, I want to underline the word open air. So it's, if the university's doing research, it's indoors, this has no effect on where it's not open to where there could be either wind drift or bee pollination or other kinds of cross-contamination. And just to give some context in terms of the GMO issue, there's different types of legislation that has been brought up nationally and on the state level. Some of it is consumer-oriented, right-to-know laws, pesticide regulation laws, patent, intellectual property laws. But my focus is on agriculture and protecting the farms and the properties that are non-GMO. And I think the key to this whole problem, what is the problem, is that GMO, genetically modified organisms, in other words, the genes are being tampered with, to oversimplify, are dominant. So if you have a farm that's GMO, growing GMO crops, and one in the neighborhood that's non-GMO, organic or conventional, there's cross-contamination. And once that there's absolutely no science that says that contamination does not occur. So you have it in terms of the genes being basically taking over, going in and trespassing, and that farm then becomes a GMO farm, and that's what happened with the papaya in our county. Is suddenly all the organic farms were becoming GM that wanted to continue to be non-GMO were suddenly becoming all GMO dominated. So if you'd like to give a little more context in terms of the problem and
Sure.
why we're working on this.
Sure. I just wanted to point out that the issue of contamination by GMO crops is of national concern and international concern, and there have been many, many instances of contamination that was unexpected or that the proponents of GMO claimed could never happen and so forth, and they have been very costly to non-GMO farmers. Probably the most expensive blunder was just a few years ago when it was discovered that a GMO rice variety that had ended up in the conventional rice supply, and immediately the European Union, the Japanese markets slammed their doors shut to American exports, and there's been litigation ever since, and it's a rough estimate would be about $1 billion in damages that the rice farmers incurred from very small amounts of contamination that to this day the USDA says, even though they've investigated, they don't know how that contamination occurred, and it was supposedly only some field trials that were supposedly isolated where that variety had been grown. That's by no means the only incident. There have been numerous incidents of transgenic alfalfa, canola, pharmaceutical GMO corn, creeping bent grass, all have escaped the confines of the growers and have caused problems for the environment or for other growers. And there's a host of ways in which this contamination can occur. So it's a very real and very expensive problem.
Okay. I think the key question that I saw before our council was, do we draw the line and say no more GMOs till we look at this further? And when I say look at this further, we're planning to set up an ad hoc committee to continue the discussion and determine if there's any coexistence possible and how to do that. But the question was whether we instead, let's just defer the bill and go on and have a study group and study it and then see what the issues are and come up with some proposals. I felt we should be guided by the precautionary principle and not ignore the cries from not just in Kauai and other places where there is so much GMO ag going on, but around the world. And that one of the problems is in terms of risk assessment is the whole GMO contamination is so irreversible. And in light of the potential harm and the irreversibility, that we should close the door while we discuss this and not instead go on our way and say, come on in, whatever ag chemical companies want to come in here and grow their GMO crops. So that's really what it came down to. And I think that in light of the overwhelming testimony and the overwhelming concern around the world, and in particular the concern about the most vulnerable populations, which clearly with the GMO, what everyone has found, and the doctors and midwives and obstetricians, it's with the children, and unborn children are the most vulnerable to these, and finding so much toxicity in unborn children and in the placenta, and that we really need to act in a cautious manner. So that's, I think, what the council went with, and we had the bill passed in last month in November, and on 6-3, it's now before the mayor, and the mayor has the choice to either sign it, which we hope he will, or let it go in to become law, or veto it. And clearly, if he were to veto it, the council would seek to override. We would need 6 votes to override a veto, which means that he would have to get one council member to flip-flop who supported the bill and stood for the bill to now say, no, I don't no longer support the bill, and I will defer. I do think that the mayor is in a difficult position. It's very controversial, and a lot of what I would call the big guys like the status quo and talk about freedom to farm, and you can't encumber any farmer, and that this is an important technology and you're getting in the way of science, and arguments that at least on the surface sound great, like how can you stand in the way of science? And I think that it really goes, in my mind, if you were to take at one point what went wrong, it would be the determination in 1992 by the federal agency that said GMO crops are substantially equivalent to their corresponding non-GMO crops, and therefore generally there's no need to undertake independent health safety studies before allowing these crops to go into the marketplace. Now, there are some exceptions to that now with pharmaceuticals or industrial GMO use. But basically, it just gave them a free ride. I mean, that is the most unscience, Mark. I mean, here it is. No, we don't want any independent studies, and we want this exemption. And they got that, as far as I was concerned. That was a political decision, and everything follows from that. Looking at Bill 13, again, what it says is prohibits open-air cultivation of genetically engineered crops and plants. And I tried to look around, what has the federal government done in terms of laws that would protect and take a cautious approach, or have any restriction in terms of protecting the private property rights of farmers, the non-GMO farmers. And the only ones I could find were bills, federal bills in 2005, 2007, and 2009 that were designed to protect the non-GMO farmer who, through no fault of his own, there were GMO crops on his property growing. None of that legislation passed, none of it. So there's no federal law protecting the property rights of GMO farmers, or contamination of neighboring properties, or contamination of the water supplies. And then on the state level, let's take a look at the state. You asked this, the governor held a community meeting on the Big Island a few months ago, and all of the questions, or a lot of the questions, well, what is your position on cultivation of GMO crops? And it was, well, we defer to the federal government. Well, the federal government doesn't do anything. So here you have, I think, our one state law having to do with food or crops or plants. There's nothing in it to do with GE. So basically, the state has taken a policy that we will not regulate this industry. In fact, we promote, and we will, as far as many of us are concerned, just cater to and kowtow to the biotech industry. And I think you found that, I'm not sure if everyone's aware that on Kauai they have a pesticide bill, and the mayor that passed and the mayor vetoed it, and his reasoning was, well, let's leave it to the state. And there are too many legal questions and that we might get sued. And thank goodness the Kauai County Council stood up for what they believed and looked at the health of their people and their obligation to protect the health and welfare and safety of its constituents and overrode the veto. And I don't know whether you've been looking at any of the sort of the what's going on the state level and look at what some of their what we can expect on the state level to try to sort of stop these pesky little counties that are actually standing up for the rights of the rights and the health and the welfare of the people.
Yes. Well, in the wake of Big Island Bill 113 and the Kauai Bill 2491, there has been a lot of discussion about what's known as preemption, and a lot of people either suggesting that these types of laws are already preempted by federal or state law. In other words, that the counties have no right to be passing these kinds of bills, that it's exclusively the province of the state or the federal government. And others have been promoting the idea that if it's not already preempted, then we should preempt it at the state level. And there have been bills drafted, and there were bills in previous sessions, this is not brand new, that have attempted to preempt these types of bills in the agriculture area, and more generally to strip the counties of their traditional power to protect the health and life and property of their residents. I mean, if the current law in Hawaii says that that is what the counties are authorized to do. That's their job, is to protect health, life, and property. And there are bills, for example, Senate Bill 727 in the last session, which was introduced in an effort to essentially gut the county's authority and say, no, you don't get to do that. That's way too much. Here's a few things that you can still regulate, but we're just going to let the state do everything else. And I am fully expecting there's going to be a big push this coming session to introduce or resurrect legislation that will, in every way possible, make it impossible for the counties to regulate in the ag area and maybe other areas too that may inconvenience the ag chemical corporations.
I want to go back to what you said about Bill 727. And that was a bill that was described as for title Economic Development and described as to avoid conflicts between local and state and federal with federal laws. But if you looked at it on, I think it was something like page 13 or something, it took our home, the county's home rule statute, what authorized us and gives us power, and took it and eliminated the words health and life and left only the right to regulate property and secure order. So I found out about this bill. I just by chance found it on the website, and it was coming up the following day, and I said, this is the provision in the law that I quote when I go to court as to why the county has jurisdiction over anything having to do with the well-being of the people. And so I just decided I'm going to go to this, and I went over there, and I just went there and I said, is this a joke? what are you doing? Are you trying to put an ocean between the people and the first layer of government? And I just, what's going on here? This is absolutely unacceptable. And I just don't understand what's going on. Well, I found out a few minutes later what was going on when I realized who was testifying on the other side. And it was Monsanto and the other biotechs and the Hawai'i Crop Improvement Association, which is basically their lobbyist advocate arm, and as well as a number of persons from the mainland, and explaining that that local governments and people get in the way of their corporate policies, of their corporate objectives, and that they have succeeded in gutting county jurisdiction in this way in over 20 states. Well, I was the only government official, county or state official, who was there, and we got it deferred, and I think there was one county, Honolulu, their corporation council submitted written testimony, and the written testimony said keep confidential and privileged, but it noted this would undermine, basically gut county jurisdiction. Anyway, that bill has been deferred, but it will be resurrected this coming legislative session unless it's stopped. And I also wanted to bring up another piece of legislation. It was SB 590 concerning the Right to Farm Act, and that bill, or that law as it currently stands, it was to protect farmers in the wake of urbanization encroachments so that you couldn't bring nuisance litigation against farms, basically where it was disturbing sort of new urbanization on ag land. Well, SB 590 was introduced this past session, and again, I expect it'll be resurrected or in some other form, and it would expand it to clearly cover, to protect all ag technology and basically the biotechs, and prevent any kind of now not just litigation but laws or any kind of interference with any farming. So again, this would say that no county, no state legislature, no court could say anything that would in any way undermine the rights of or the biotech GMO agricultural practices.
Yeah, the whole idea of what counties can and cannot do is an issue that has played out for many, many years on a lot of different issues, and agricultural issues in particular. 25, 30 years ago, there was a lot of litigation over whether the federal pesticide laws preempted counties' abilities to regulate pesticide use at a county level. And some courts said one thing, some other courts said another thing. It went all the way up to the U.S. Supreme Court, which said, no, the federal pesticide law, known as FIFRA, does not preempt the county's authority. So the chemical company lobbyists went out across the country to all the state legislatures and said, okay, now you guys, we want you to pass legislation that expressly precludes the counties from regulating anything having to do with pesticide use. And at this point, there's about 41 states that have that legislation. Hawaii does not happen to be one of them. So it currently is within the county's authority to do that. But as a general matter, these arguments for preemption of county ordinances are almost always, in fact, as far as I can tell, always at the behest of the big businesses who simply don't want to be hassled, don't want the inconvenience of having to comply with regulations. they will say, as they are saying now, that what we need, the reason we need state preemption of county laws is we need uniformity. But what that really means is they don't want uniformity, they want uniformly, lack of regulation is what they want. If you say, well, fine, if you want uniformity, why don't we have a statewide regulation that applies to all the counties, just like the Kauai 2491 or the Big Island 113. Let's make those uniform. They'll say, no, that's not what we mean by uniformity. What we mean is uniformly in our favor. Mm-hmm. And so all of these preemption bills are always being pushed by those types of companies.
Right. And you brought up the federal legislation that FIFRA, and I also wanted to hone in a minute on the Federal Plant Protection Act. And this is another law that Bill 113 has been challenged, that no, this violates, could be in violation of the Plant Protection Act. But I want to just sort of make clear that as our corporation counsel has said, and that's the county's attorneys, back in 2008, that is not the case, and that it would inhibit the state or the county from doing something that governed the movement of crops from nationally or internationally, but it does not have to do with the growing of crops. And that opinion first came about in 2008 when Hawaii passed its first, what you might say, call anti-GMO legislation, and that was to prohibit the cultivation of GMO coffee or GMO taro on the island of Hawaii. So really, Bill 113 is just following along and saying that that this is a policy that we want on this island. This is the ag policy that we want. And Hawaii, sort of, what is the ag policy in different counties does vary. I mean, and the cultural identity varies. I think right now there was recently the Hawaii Civic Club's convention, their statewide convention. They passed a resolution that basically reflected Bill 113, and that was almost a unanimous vote, and that this is important also on a cultural level, not just environmental health and safety, but a cultural identity, and that the people identify with the land, and the health of the land reflects the health of the people. And one thing I sometimes say is that, well, what I'm doing is protecting the soil and the microorganisms, and the microorganisms help protect the health of the plant and help protect those who eat the plants, and that indirectly then it is helping protect people and the whole web of life. I know we had sort of people in the honey industry come and say that if GMOs are not stopped and not prevented further spread on the island of Hawaii, it will be the last nail in the coffin for the bee industry. That the state has done a poor job in keeping out other pests, but this one, that the health of the bees is impacted by the GMO and the associated pesticides. There was a international foundation doing research on bees, and lo and behold, it was bought out by, I believe it was was Monsanto, and the door was closed. So no more independent study in that area. But I think that considering all the concerns, that we need to proceed cautiously, that if we were to just become one more GMO-dominated island and follow in the footsteps of those who are now saying we're suffering, would just be irresponsible, and I think that's where our councils come. I do want to sort of bring up a couple arguments or questions that are often raised, and that is, well, Margaret, isn't this going against the freedom, the right to choose? And I just look at it as, where does your right to choose so harm another's right to choose that we need to draw the line? That what is that? What is that right? Is it just that if you grow GMO, you're allowed to continue and operate no matter what the harm to others? There was one organic papaya grower that testified recently, and what he said was he was growing organic papaya and selling it, and all of a sudden he became aware that it was 70% GMO, and that it had been contaminated by another papaya farm in the area. And he was so afraid of the approach that these biotechs have taken in terms of litigation that he cut down every papaya tree on his property. And what he explained is that, and others have explained, is that if these volunteer trespassing plants grow on your land, then the patent holder, in this case, let's assume it was, I don't know whether it was Monsanto or other, can come in and claim they own your crops. In fact, they have, can't remember if it was in Canada or in mainland or both, come in and claim the profits of all of that crop. And I don't know whether you've seen any of that going on.
Well, Monsanto in particular is notorious for intimidating farmers and by saying, well, we found some of our patented plant growing on your property, and the farmer will say, well, if that's true, I don't know how it got there, because that's the last thing I want on my property. And they'll say, well, be that as it may, we own the patent and we're going to sue you. We're going to drag you through the courts. So if you want to go there, we can do that, or you can just pay us a lot of money to go away. And they've done this many times, and this is very well known. The problem of this sort of contamination, it's not only when contamination actually occurs. The problem also is that there is a constant threat of contamination, and the non-GMO farmer has to test his or her crop on a regular basis to ensure that it is not already contaminated, or else he's passing on something to his market that market rejects. And as a result, and I have seen this happen, I have represented farmers who have told me that now, just because there are GMOs growing in their area, there are some customers that will no longer buy from them because they just figure, we don't want that risk. Our customers don't want GMO. You have GMO where you farm. We don't care what your tests say. We're just going to find some other supplier. So that's a real problem, and it's a very expensive one.
Yeah, and I think what happened with that wheat in the Northwest was sort of a wake-up call on that, where was it wheat? No, it was alfalfa.
Well, there's been wheat, there's been alfalfa, there's been canola.
Right.
They've all gotten out.
Right. So here it is, where it's say in the Middle East or Saudi Arabia or other places that are importing a lot of this, and where they say, we're going to check the containers. If we find one bit of GMO, one test of GMO, all of this grain goes back at your expense. I mean, it really, and that's why I sort of look at, how can Hawaii Island, at least there's this one island that has, other than papaya, there's one farm with corn, has not been taken over, and how can we, in a way, take advantage of this opportunity to supply non-GMO crops or seeds? I know when I've researched how do we, on the mainland, there are a lot of corn farmers who are asking, I want non-GMO. And they're saying, we just can't get it where it's reliable. I mean, I actually went on the internet and tried to see, well, where does it say certified, non-GMO corn seed? I came up with one place in Vermont and one in Germany. I mean, so I think that reflects what's going on a whole nother level, and that's sort of this corporate takeover of our food supply. I mean, the biotech companies have pretty much taken control of soy, corn, alfalfa,
sugar beets,
sugar beets, both here and in Canada, so that as people say, those that control the food control the people, and that's what the experience has been. I also find a lot of farmers who just very innocently say to me, well, Margaret, I just want to try this GMO. Why don't I just try a little GMO for a year and see how it goes? They say I can get a really good deal on it, and maybe I can get some free seed, and that's what predatory monopolies, oligopolies are all about, making it really easy to get into whatever they're promoting. And so when this farmer said that, some other farmers who are doing, two of them that are doing organic, said, but if you do that, then I cannot grow corn, and I'm making my money on for organic corn. And maybe we can work this out. No, as long as there's drift, there's bee pollinated and wind pollinated. It's dominant. I mean, this is like, these are aliens. They can just come in and they dominate. It's not like, okay, maybe the organic genes are going to win out. But I think that often farmers don't realize that what's involved when you start farming patented seeds. They basically, in my view, are no longer farmers. They're patent licensees. They come in and you want, okay, Monsanto, I'd like to get some of your seeds and try it out. And it's, well, okay, and here's the good deal these first so many years or to start with. And then, here you have to press the I agree button to say that you'll agree with the manual on agricultural practices. Oh, well, okay, I do that on the internet every time I want to get on, practices. But what is in there? I mean, it changes. It almost goes back to sort of plantation feudal farming, where you allow in that patent holder takes rights.
There's nothing more fundamental to a farmer's independence than his or her ability to save seed from year to year. And that's exactly what these companies are precluding when they patent the seed and make you license it. You have to come back every year and buy your seed from them, and you cannot save your seed from year to year. And this is sort of the master plan, which is for a handful of multinational companies to be able to say, if you want to grow any of these commodity crops, you must come to us. And that is the model that is slowly prevailing, and it's extending beyond the commodity crops like corn and soy and cotton and sugar beets, and now they want to patent a wide variety. They are in the process of trying to patent a wide variety of fruits and vegetables, so that eventually you want to grow pretty much anything, you're going to come to them.
Yes, and so if you are growing their patented seed, not only do you lose the right to keep the seed, you also, there have certain conditions under which they can come in and check your fields and make sure it's all the current year seeds, and they can review your records, make sure that you're not somehow going against their policies. And if you have a complaint with their representations and their seeds, and you want to go to court or you want to do something about it, you got to go to Missouri, a particular county in Missouri, and the limitation on your rights is to get new seeds or the price you paid for the seeds.
Well, and also the vast majority of all of these genetically engineered crops are designed to be resistant to herbicides. And so when you are agreeing to buy these genetically engineered seeds, it's as part of what they call a system that is patented seed plus the chemical, that you would not be growing the crop unless you wanted to be applying this chemical that the crop is designed to be immune to. So you're basically going back to the company not only for the seed, but for the herbicide to spray on your crops, which is the whole point of growing the seed in the first place. So you now have this relationship where you're buying your seed, you're buying your chemicals from the same suppliers, and you're locked in to this agreement. And what tends to happen with a lot of these herbicide-resistant crops is over a period of time, the weeds start developing resistance to the herbicides themselves, and so you find yourself with a field full of herbicide-resistant weeds, which is exactly what has happened in corn, soy, and cotton in the rest of the country. So then the farmer says, gee, what happened? I thought I was doing this so this wouldn't happen. Well, it does happen, and it's become an extremely big problem across the country, these herbicide-resistant weeds, which is why these companies are now developing the next generation of GMO crops, which are resistant to 2,4-D, so that they can now apply 2,4-D, which is known as a component of Agent Orange, can be applied to these fields and kill the weeds that are now resistant to Roundup, which the previous generation of GMO crops was resistant to. So you're getting into this spiral of more and more toxic chemical use, which is really inherent in the whole GMO approach. Mm-hmm. And I think people don't necessarily realize that growing GMOs is a chemical-intensive system. It's designed to be that way. It's not designed to feed the world, to be healthier, to be, need less water, any of these other things. That does not exist. That's industry hype. What exists are crops that are designed to be immune to herbicides that the company will then sell you.
Okay. And I think that whole, who are the biotechs? I mean, they are chemical companies. You've got Monsanto and Syngenta and Dow and DuPont and Bayer, all of them. That is their business. And I think that as we watch sort of what has happened in places where they are doing GMO crops, I find that at first, okay, they're using less pesticides, less herbicides, but it's not too many years before suddenly they need more and more and more. And I think that's the reason, like, for example, they've gone into the U.S. government to be able to leave more and more residue on the crops and increase the amount of toxicity. I mean, keep in mind, basically, where these Roundup Ready crops or GMO crops are so that you can pour all of these chemicals and pesticides and toxins on the soil and indiscriminately on the crops because those crops are going to survive. Right. And a lot of one of the things that's been testified, or people testified on Bill 13, was to say, well, if Monsanto and those guys are such a bully, can't we separate that out? And we just want to, use these GMO seeds. Can't we separate those two? We don't have to allow all these big multinational chemical companies to come in. But there is no divisibility between them, their seeds, and their pesticides. It is where our patent laws, our intellectual property laws, trump all else. And they are strict liability laws. And that's why, you're growing it in your field, and it's, we own it. it's ours. I mean, that's the way the patent law works. And there have been some efforts to change some of these laws, and they've been totally unsuccessful, even in the case of the innocent non-GMO farmers. So you don't, you cannot separate out the chemicals, the poisons, and those companies. And I think one of the, I look at Bill 113 as really modest. I mean, it is so, everybody that's already GMO, you can do it. Not a job is lost. Nobody changes from the day it's here and the day it's there. Now, the papaya industry, people have said, but Margaret, it taints us, and you bring up this GMO, but we're the messenger for what's going on, the concern worldwide. And I do think the papaya industry, or people find themselves in a difficult position because this was promoted, the GMO papaya, by the university and promoted rather than say, cut the trees down and don't do them for another year, or the other options. And so what they did was perfectly legal, and they did a lot of extra testing, and which is true because they wanted to get into the Japanese market. So as compared to, say, some other crops, they have done more research and more studies, but they have never been required to do animal or human testing.
Yeah, I think that's another thing that people don't realize. They think that because something is allowed by the federal government, that some agency like the FDA or somebody out there is actually testing these crops before they're allowed to be on the market, and they've been shown to be safe. And of course, the companies will imply that somehow. This is so highly regulated. There's no evidence. Blah blah blah. The truth is, the federal government does not test GMO crops. Period.
Right.
And nobody else does long-term studies, and the only studies that are done are lab studies done by the companies themselves, short-term studies. Well, mice ate this for a few weeks, they didn't keel over, therefore it's safe. Go ahead. And the USDA says, done, next.
Okay, that's right. So there's no required human animal studies. They do come in, and there's a voluntary consultation process in which the companies bring in their new crop or their new GMO produce and provide information to the federal agency, but the regulators are just look at what's being provided. There's no independent review of it. The corporations can provide whatever information they want. And then they get a letter saying, according to your studies, that everything is safe and there's no pre-market studies being required, or something to that effect. So you really have, what keeps coming back to me is this false mantra of that people that are against these are against science. But that's exactly what they're doing. We want an exemption from any independent science. Plus, what's been brought out, such as by UH professor Hector Valenzuela, is that it's very difficult to do any science or studies because in order to do a study of the GMO produce or the GMO organism, you have to get that information from the corporations themselves, because although to the regulating agencies they say there's no material difference in terms of the intellectual property laws, they say there is a material difference, and therefore we have a proprietary right to this, and these are trade secrets. So there's no information given out. So I think looking at, what are the ways that these corporations have been able to become so powerful. I mean, and I want to stress that it's not just in the state of Hawaii. I mean, even on the international level right now, there are treaties, the Trans-Pacific Partnership, and there's one going on in Europe, treaties going on, and there's intellectual property sections that are to protect the Monsanto, all of these agendas, so that nations and states cannot interfere with their free movement of their patented seeds. Or on the federal level, you even had that Monsanto Protection Act, that they're able to get something into that, but budget legislation and prevent and block any federal legislation.
What that was actually an attempt. What they did was they put into law, which thankfully has since expired, a tactic that they used in response to a lawsuit that I was involved in which we managed to stop the production of genetically engineered Roundup Ready sugar beets until they did a required environmental impact study, which they had not done. And in order to continue growing, despite the court's order, they went to the USDA and said, give us a special permit that says it's experimental, and we're just going to keep growing commercially under this experimental permit, and we're going to somehow try and get around this court order that told us that we're not allowed to grow. So, and this actually worked for the industry. The court saw through it, issued an injunction, and said they wanted that crop. The court wanted that crop pulled out of the ground, but that injunction was reversed at the Ninth Circuit level. But in any event, the Monsanto Protection Act was an attempt to say, you know what, in any future case where a court says, you know what, this crop was unlawfully put on the market, we want to take away from the court the ability to stop us from growing it while we go back and comply with the laws that we were supposed to have complied with in the first place.
Right.
And the outcry when people realized what had been done was so great that that Congress said, okay, this is never going to happen again. We're not going to renew this law.
Right. And I think it is so amazing how much power these corporations have. And I just even look at in the state of Hawaii, where the efforts to get in some kind of labeling law, they were not able to get a hearing on either the Senate side or the House side for so long. And it wasn't until just recently when there was a new chair to the House Ag Committee that the first time there was even a hearing on any of these issues. But so I think when we look at our state legislators, or you look at the mayor, or you look at the governor, and there's so much intimidation and lure. I mean, these corporations give a lot of money to the University of Hawaii. I mean, I spoke to one of the administrators at the University of Hawaii who testified, and I said, I am so disappointed in your testimony. You make it sound like this is science versus fringe. And he said, this is where we're getting our money. We are in a difficult position. And I think that puts the governor in a difficult position when whether it's campaign contributions or ability to contribute to the important nonprofits such as the university. It really is, it takes a lot of spine to stand up to them. And I guess the bottom line is I'm certainly hoping that our mayor signs the bill and has the spine, and that our state legislators see through this and take the time to look beyond the superficial arguments. I know we don't have much time left, so I do want to mention that if you are interested, and I urge you to become involved in this conversation, I believe my office phone number and office email address is on the screen. Please do get in touch with me. I also know that there are sort of pro these GMO restricting legislations planned for around the 14th or 15th of this month. And if you are interested in finding out more about those, you can contact Ben Cohn, and his email address is livingfoodhawaii@gmail.com. And I urge you, assuming that Bill 113 is become law, we are going to have this follow-up ad hoc committee to sort of continue the discussion and work out the nuances in terms of whether it's enforcement or potential coexistence or the registration provisions. And there's an emergency exception. So I urge you to become part of this conversation. We are at a turning point and a tipping point where which direction do we go? Is our future in the hands of these chemical corporations, or is it in the hands of the people and the local level to protect and look at stewardship and more eco-friendly farming practices? So regardless of what your position is, I think that just having adult conversations about important issues and controversial issues is important. I know I've made a point to listen to everyone and anyone who's concerned in this area. So we hope that you'll follow what's going on and stand up for home rule for the County of Hawaii and for local government. I think you're going to see that this issue cuts across Republican and Democrats. It's that the people need to have a say and not big government, big corporations controlling the world of food and our soil, and that we have a responsibility to stewardship for an obligation under the public trust doctrine of this state to protect not only the current generations and the current farms, but also the future generations, and the stewardship of the soil is what I see as the key to sustainability. And I think that sustainability issue is where it's at. It's not just how much food, it's how much healthy, nourishing, safe food and healthy soil is what the people have spoken, and that is what that is the direction we're going. And hopefully the island of Hawaii takes this little step and further that direction. Okay, and thank you for listening, and please be part of this.